welcome to the program. We start off with Abia State in Nigeria's southeast, where a political and legal crisis have left virtually everyone in Nigeria confused as to who is the legitimate governor of that state. Of course, we have always known Okezie Ikpeazu to be the governor of the state, but things changed and perhaps got muddled up when a federal high court in Abuja on June the 27th found Ikpeazu guilty of tax evasion. Justice Okonabang ruled that Ikpeazu was not qualified to have stood for election in the first place, and that the man who came second in the PDP governorship primary that produced Ikpeazu as the party's candidate should be presented with the certificate of return by INEC and consequently be sworn in as governor. INEC has since complied with the court judgment and issued Uche Oga the certificate of return as the elected governor of Abia State, but he has still not been sworn in. Let's take a listen now to the INEC commissioner in charge of the southeast zone of the country explain why INEC had to comply with the court order.
Yeah, the situation is that we are simply obeying the court order. Court says with immediate effect, without wasting of time, that INEC should issue that certificate. We just obey the court order. If tomorrow another court overrules, I am, by God's grace, I thank God, I am the INEC National Commissioner representing Southeast. I will do the same thing to another court. We are not above the court. The court says we should give certificate of return to the person who won, and that is Dr. Uche Oga. And that is why we have given. I was the one who gave certificate initially to Ikpeazu, because he was declared winner. Now court has said otherwise, and we cannot do otherwise. We cannot say no. We will not do. We are not above the law. We all obey the court. And another person we obey in our life is God. If my conscience is clear, and I have my conscience is my God. And another thing that guides us is the court, and we must obey the court order.
Well, the commissioner's explanation there may have seemed simple, but the whole situation is not as simple as that. And in fact, that is where the legal conundrum actually begins. Ikpeazu still occupies the governor's office in Abia State, insisting he remains the governor of that state until he exhausts his appeal. He actually has the right to appeal. But Uche Oga is insisting that since he has a certificate of return, he should be sworn in as governor. So the situation in that state is that of a stalemate. The issue is generating serious debate among lawyers in this country. Some argue there is a substantive governor in Abia State who is yet to exhaust all legal options available to him to seek redress on the matter, while others say that Ikpeazu has that the Ikpeazu appeal actually against the court judgment does not mean Uche Oga should not be sworn in as governor. Now, counsel to Ikpeazu, Wole Olanipekun, has filed a stay of execution of the judgment, while counsel to Oga, Alex Izinho, has filed a counter affidavit. The ruling has been fixed, of course, for next week. But while we wait for that ruling, the question is this: is the governorship of Abia State, or the governorship seat, I should say, is the governorship seat of that state now vacant? Joining me to discuss this further are two lawyers. Onyekachi Ubani is the former chairman of the Ikeja branch now of the Nigerian Bar Association here in Lagos, while Onyebuchi Memanka is also a lawyer as well. Gentlemen, thank you very much for coming on the program.
Thank you.
Let me start with you, Onyebuchi. Quite a lot of confusion. You are a lawyer. Thank God both of you are lawyers. But give me your own take, I mean, from the legal perspective now, on what is happening in Abia State.
Well, first and foremost, the office of the governor of Abia State is not vacant. Dr. Okezie Ikpeazu is and remains
the governor
of Abia State. What happened last week was,
despite the judgment of the court?
Yes. What happened last week was equivalent of civilian coup d'etat to sweep off, like a tsunami, to sweep off a sitting governor from office. The judgment of Justice Abang, we have taken note of the judgment. We did not just, the governor did not just take the judgment line low. He invoked the his constitutional rights of appeal. Now, you see, The reason why it is always better, neater, and in a constitutional democracy to allow procedures or to allow for procedures to be followed is for to allow a situation where there will be no confusion. Take, for instance, if Dr. Oga had been sworn in last Thursday, and of course, Governor Ikpeazu continues to pursue his appeal, and 1 month, 2 months after,
And if Ikpeazu got
judgment by the Court of Appeal, so what happens? What happens? You see? And within that 1 month, of course, assuming Icho had come in, he would have taken certain steps. He would have fired commissioners, probably PAMSECs, taken economic decisions, cancelled contracts, awarded new ones. And 2 months after, Court of Appeal says, no, the High Court was wrong. Dr. Ikpeazu, go back to office.
And then Oga appeals to the Supreme Court.
Absolutely. So it is always better, it is always neater in a democracy to avoid confusion, to allow the entire process play out. So that at the end of the day, when the Supreme Court gives judgment, we wouldn't be here discussing this.
Is there a chance that INEC was actually not put on notice? That's the reason why it went ahead to issue that certificate of return. Because I've heard arguments from some other lawyers that, there is a chance that, INEC was actually not put on notice in terms of the appeal now. And that's the reason it had to act. And because without no notice of appeal now to INEC, I mean, it just had to issue that certificate of return.
INEC was duly put on notice. INEC was not, they were served with the papers. Remember, initially, INEC was saying that we do not have any document at all served on us. No notice of appeal, no stay of execution was served on us. Not until the Abia State Attorney General presented to the press documents, evidence, documentary evidence of receipts, what we call affidavit of service in law, showing that these documents indeed got to INEC. It was then that INEC beat a retreat and said, oh, well, we actually got the notice of appeal, but we didn't get the stay of execution. How do you believe such a person? A law will say, nullius in singulus, nullius in paribus. Whenever a man lies first, don't believe him again on that issue. I mean, you see, the Supreme Court in Ojukwu and Governor of Lagos State made it clear that while expounding the doctrine of lease pendens, that once a party is aware of an appeal by the other party, it is better. It is always better to wait.
To wait. Okay, let me just pause you there for now and bring you in, Onyeka Chubani. I know also that you've been defending the cause of Uche Oga as well. Tell me, really in law, when there's a notice of appeal, is it not the tradition that you stay action on a particular judgment until that process has been exhausted?
Thank you.
What is different in this case?
Thank you, DEJI. Thank you very much for my colleague also. It's important that what we are here to do is to educate the members of the public, including non-lawyers. They want to learn from us.
I actually
and it's very important. The elementary truth of the matter is that appeal does not operate as a stay at any point in time, unless there is a specific provision of the law that says so. Just like in section 143 of the Electoral Act, when any office is invalidated by the court, by the tribunal, or the court, and court there was defined as the Court of Appeal when it is sitting in a primary jurisdiction to hear presidential election. That the Court of Appeal is the first court you go to when it is a presidential matter that is being litigated on. Now, when you have your election invalidated under the tribunal, what you do is that you have 21 days within which to appeal. In other words, you must allow you that 21 days to exhaust. If you fail or neglect to file your appeal within 21 days, you have lost that right permanently. In other words, you have to vacate the office. But if you exercise that right within 21 days, the law went further to provide that appeal itself operates as a stay. In other words, what it's trying to say that issue of appeal does not ordinarily operate as a stay. And that's why the law was very explicit with regards to decision reached by tribunal, that if you do appeal, that appeal operates as a stay.
But that's in the case
case of tribunal. But in pre-election matter, there is no such thing. It is the normal procedures the civil procedure that will apply. So if you file an appeal, it does not operate as a stay. Even if you file motion for stay, for God's sake, in the absence of any express order, my colleague is here.
Okay,
If you, even if you have notice, even if you have notice, let me finish this. Even if you have notice that appeal is a stay, that somebody of a
if you
motion,
have notice
of motion, not
motion, okay.
If I disobey it, I cannot be committed for contempt. You know why? Because there is no order. He knows it. If for somebody to be cited for contempt, listen to me, because when they call, even the authority is cited now, Ojukwu, he says it's advisable. But not that there is any law that says if you disobey, just like I want to make a case with you now, I serve you my statement of claim and writ of summons. Does my notice of my action constitute an order of court?
Could that be the reason why the council now to Ikpeazu Wololani Pekun has decided to file
a motion for stay, which is what they have done. They have done the right thing now by going before the same court. But if they have succeeded now in transmitting their records of appeal, maybe the appeal court now will be the right court to now hear the motion for stay. So I'm saying that they have done the right thing now by bringing a motion and a date has been given for stay because there is no express stay. He knows it, and that's why they are arguing.
Uche Oga had actually been sworn in as governor immediately. Yes. And this Ikpeazu eventually got the motion of stay of execution now granted. What would have happened?
No, it couldn't have, because it's already executed. You don't stay something that has been executed. If it has been sworn in, there is no question of stay. What will happen is that Mr. Dr. Ikpeazu will pursue his appeal outside the division because the man has been sworn in. Because in fact, the order of the court says that he should be issued with the certificate of return immediately. We must be very, this of what the judgment of the court says, that he should be issued with the certificate of return immediately. He should also be sworn in immediately. That word was used. And so, I have the copy of this. I was in court. It should be. I have the court. I have the court order. So the word immediate was used. So that's why he had a road order and went to INEC, and INEC complied with the order. So whatever it is that because of the fact that normal things are no longer normal, because institutions and agencies do not obey court order, when there seems to be a compliance to court order, ordinarily, people now regard it as strange. Oh, why didn't you wait a bit? Why didn't you look towards right and towards left? But can I ask you this? That's the wrong procedure.
What then would have happened if, let's just picture this scenario.
Yes.
As he said, Uche Oga got sworn in as governor. He took office.
Yes.
And Zia Ikpeazu decides to pursue his appeal, and he gets a judgment in his favor. What happens?
Yeah, that's you are supposing now.
Yeah, that's what I'm just.
But it's not a reality, because if you see the judgment and all that, but good, he has an appeal, to pursue. But if he succeeds, of course, the act reverses, depending on what the order of the court also will be at the court of appeal. If he says he should take back his seat immediately, as the lower court has also instructed or ordered, that will be it. Until finally the matter is decided at Supreme Court. There's nothing comparing this particular case with murder. If somebody has been committed for murder and then you execute him, it has nothing to. There's no similarity. I saw some people citing the murder case where somebody appealed, and before the appeal was here, he was executed. That the man's life is completely lost. But this is something like a race that can still be restored. If he now wins, he gets back his position. But for now, he is no longer the governor based upon what the court has made a pronouncement on, in the absence of reversal of that order, in the absence of any staying of execution order. If any lawyer comes here and tells you anything different from the law, what the law says, all those one they cite is because it's only advisable. It's not a ratio. Okay, it's it's not a ratio. It's obiter. There is no way a lawyer will come and tell me that if I serve you notice of appeal and you disobey the notice, the grounds of notice, that the court will cite me for contempt. No, you will not. The court will only say it's only advisable if you have waited, but not that somebody has disobeyed any court order because there was no order in the first place.
Can I get you to react to some of the issues?
Absolutely. Election cases, election petitions are sui generis. By that I mean that they are not like the normal court cases. Particularly, the position of the governor of a state, the president of the Federal Republic of Nigeria, decisions affecting them cannot be interpreted the way the normal civil procedures matters are handled. The reason is that when a governor is in office, he is not just in office. He takes far-reaching decisions that touch on the welfare of the people. Can you imagine a situation where, let us assume that one of the presidential candidates had taken President Muhammad Buhari to court or to the election tribunal, at the court of first instance in this case now. And as soon as that court gave order reversing the president's election, attempts will be made to swear in that person. Even when the president still has the right of appeal. What do you think would happen? How do you think the international community... I'm coming.
He just said it applies only in tribunal cases.
No, that's not what he said. What he said is different. I said, in a situation where the court of first instance in a presidential election tribunal, which is the court of appeal,
that's quite wrong,
gives an order asking that Mr. X of XYZ party should be sworn in as president. And the president's lawyers have appealed that decision, but the man who got judgment at the court of first instance wants to be sworn in. What do you think will happen? Now, let me draw your attention to this. In 2007, Governor Peter Obi, former Governor Peter Obi of Anambra State, if you recall, he instituted a pre-election matter when INEC wanted to conduct elections in Anambra State. And he said, look, my tenure is not, I've not completed my first tenure. How can you conduct an election? But INEC went ahead, conducted an election, and issued certificate of return to Andy Uba, and he was sworn in.
And Andy Uba was there, of course, for just 17 days.
Beautiful. Now, when Governor Peter Obi got judgment at the Court of Appeal, he never rushed into office to take over. Andy Uba appealed to the Supreme Court. Yeah. Peter Obi waited. Even though he had a judgment, Peter Obi waited until the Supreme Court decided. And when the Supreme Court decided, of course, that's the final court, Andy Uba quietly walked away from the government house, and Peter Obi went back. So the question we are asking, the question we keep asking is, why this hurry? Why this inexplicable hurry to get sworn in? After all, I was in a TV program yesterday, and my co-discussant, who is also my learned colleague, said that he doesn't understand the hurry, because assuming at the end of the day, Uche Oga is sworn in, assuming his tenure of office will begin to run from the day he takes oath. Why is he in a hurry?
Anyway,
the position of governor, sorry please, the position of governor is one that should be treated with a lot of care. This is why my learned friend quoted one case. I am very much familiar with the case. That case dealt with a National Assembly matter, not governorship. By our constitution, you will remember that a member of the National Assembly cannot decamp to another party, except his party. There's a division. Yes. But a governor has no such restriction under our constitution. A governor can move.
And we've seen governors move.
Governors have moved. When Atiku Abubakar was the vice president of this country, he moved and remained in office. These executive positions are treated carefully with a lot of caution by the law. Because if you move them, if you shift them anyhow, without allowing the entire legal processes to play out, you will be causing a lot of turmoil in the states and in the country.
Okay. So, Mr. Bani, for me, really, what is wrong in waiting for the process to the legal process now to be exhausted before an action is taken, say an action like swearing in Uche Oga as governor of the state?
We must understand, the jurisprudence behind a successful litigant enjoying the fruits of his success. Because see, we don't look at the issue of fairness, equity only on one side. Oh, because somebody is a governor.
There should also be fairness and equity for
the man who also ought to be there. It's a pre-election matter, as rightly pointed out, in which somebody went to court on a very good ground and saying that this man was not supposed to have even participated in the primary election. And there are grounds that were found to be very convincing that in other words, he was not supposed to have been there in the first place. And the man is occupying that position now for almost a year plus illegally, drawing salaries, taking decisions, as rightly pointed out, that is affecting your life, whereas he was not supposed to be there. And so somebody now has taken time, after how many years of pursuing this case successfully, and then court has now given him remedy, because where there is a wrong, there is a remedy, ubi juice be remedium, and he has become successful. You are not asking him again, the person who has been successful now, to now wait. You cap him, you wither him, you know, you ask him not to exercise, the right of enjoying its fruits, until the man who's supposed not to be there will enjoy all the fruits. That is not the philosophy. That is not the prudence behind somebody executing an order that has been properly made. It's a valid court order, and it has to be obeyed. And why it has to be obeyed? Because the man has been successful. He has succeeded in this layer to have proved beyond, whatever he has succeeded on balance of probability, that he has a better case, and that he's supposed to be the governor and not the man who has wrongly occupied that position. So what stops that man that is successful? What stops that man that's supposed to be there in the first place, who has been denied an opportunity over a year plus to occupy that position? Why would the wrong man continue? So I'm saying that let's look at it, because you are looking at it, oh, he's a governor. He takes decisions that affect your life. I also take this man into consideration, who's supposed to have been there all this while, but who is not there, and who have been denied an opportunity, and he has become successful before a court of law. And you're asking him, keep on waiting until the other man who has been unsuccessful now will come up and then exercise his own right. Then you are not fair to the man who has been successful. So I'm saying that we balance this thing. I agree that he's a governor who was here, and the Supreme Court has held that PDP won the election and all that. He has taken decisions. But the thing we are talking about now is a primary election, in which he was not qualified to have even participated. Now he succeeded in doing that, and then he has been there, occupying position, drawing salaries, drawing allowances, and this man has gone to court to say that this man ought not to have been there. So let's look at it from that side. Because I don't like expressing sentiment, but I express law. I have talked law, but he is now addressing sentiment. I'm also taking time now to address sentiment, that we should not look at only one man's sentiment. Look at the man who has also been successful over this particular matter, that he ought to take the bite, and all along he has not. Somebody has been taking that bite for almost a year plus, enjoying all the goodness, all the glory of office.
And talking about law now, I know, certain issues have actually cropped up.
Yes.
Especially issues, questions, for instance. I've had lawyers ask questions, for instance, over the grounds on which the governor was found guilty.
That's
the issue of tax evasion, for instance.
That's right.
That it's not an issue at all that, that the Constitution is so specific about that. A governor can actually be removed on the basis of that. I don't know what your take is.
I just want you to give me 2 minutes. I'm asking for this, and it would take me time to give you all the basis of the fact that tax is a prerequisite for you to be a governor in Nigeria.
Please go
it's
on.
very, very important. Let's look at section 24F first. 24F, paragraph F of the 1999 Constitution as amended. Look at what it says. 24F, it says, 24F, yes. It says, it shall be the duty of every citizen to, F, declare his income honestly to appropriate and lawful agencies and pay his tax promptly. So an issue is that that particular issue of tax is a constitutional issue, first and foremost. But let's go to the qualifying factors for a governor, and that is section 182. 182, subsection J, paragraph J of the 1999 Constitution. It says, no person shall be qualified for election to the office of a governor of a state if he has presented a forged certificate to INEC. If he has presented a forged certificate to INEC.
What kind of certificate?
Yeah, the certificate was not defined. Include what you do is that the guideline now of the political party will define the certificates you will submit. It includes birth certificate, it includes educational certificate, it includes what you call tax certificate. Are you following me? Now, in the case of Buhari's matter, when he was a member...
Is that your own interpretation?
Yes, a certificate, it didn't define it. So it means, what is the guideline? So let's even assume, but not considering that this particular section now I've just cited now is not specific as to what certificate. Let's go to section 177. 177 now qualifies who becomes a governor. It says, a person shall be qualified for election to the office of a governor of a state if C, he is a member of a political party.
That's true.
And is sponsored
by that political party.
So if you are not sponsored by the political party, you cannot be a qualified candidate for any elective office.
But in this case,
beautiful. I'm coming now. I'm coming.
Go on.
Then the political party has guidelines for qualification to run an office that will make you now to be sponsored by the political party. Now, PDP as a political party, which is the party in question now, issued a guideline called Electoral Guideline 2014. Are you following me, sir? In which they provided a guideline that will guide all the candidates for the primary election. Now look at what Article 13, and that is Part 4, gubernatorial primary election. It says, Article 13 says, an aspirant for the gubernatorial primary election shall, use the word shall, which means it's compulsory, be a citizen of by birth and registered member of the party. 2, fulfill all the conditions set out in the Constitution, which I have given you now. The constitutional requirement set out in the Constitution of the Federal Republic of Nigeria, 1999, including issue of tax, including being a member of a political party and all that, amended. Then the Constitution of the party. Then the provisions of any other relevant law, including tax law. Are you following me? This is a guideline. I'm talking about guideline now. Yeah. And these guidelines, use the word shall, fulfill all the conditions, including this particular guideline. Now let's look at the section, the particular article that talks about tax. It goes here, that's Article 14. An aspirant to the gubernatorial primary election shall not be qualified. Shall not be qualified. This is a guideline of PDP. Yeah, shall not be qualified to be nominated or to contest the primary election if he or she, A, fails to produce his income tax certificate, okay, or any evidence that he has paid his income for the last preceding years, or evidence of exemption from payment of personal income tax. I'm coming up. Now, concerning tax, they gave them a form to fill, and that is called PD002. In PDP, they fill the form of tax clearance, and this particular page is talking about tax clearance, and a declaration is made concerning the issue of tax. When he has filled all the information about his tax, look at what the declarant, and that's Dr. Kezikbazu now said concerning the declaration page that is very important about this tax. He says, I hereby declare that the information contained in this code that has to do with tax is without reservation and equivocation true and correct. I have accepted full responsibility for the correctness of every statement and accept that any information found to be false, inaccurate, misleading, or likely to mislead the party or the agent from taking or making proper assessment of my competence to contest gubernatorial election under the platform of PDP automatically disqualifies my candidacy. That is what, and he signed under oath, signed it at Abia registry. You know the date, and it was under oath, and it was countersigned by Commissioner for Oath. In other words, any information I've given here is presumed is correct, and it proceeded from me. Now, if you found out that anything here is misleading or false, that it should lead to my own automatic disqualification. That is, he signed it. Now, let's look at Section 31 of the Electoral Act that governs primary election and all the elections. It says, Section 31 of the Electoral Act says, every political party, sir, shall not later than 60 days before their date appointed for a general election under the provision of this act submit to the commission in the prescribed forms the list of the candidates the party proposes to sponsor for election. In other words, when you have finished your primary, you now say this man is number 1 and is our candidate. You now submit that list to INEC 60 days before the election. See what Subsection 2 says. The list of information submitted by each candidate shall be accompanied by an affidavit, which one now? Sworn to by that candidate at the High Court of a state, indicating that he has fulfilled all the constitutional requirements for election, all the constitutional requirements for election into that office. Beautiful. Then 4 says, a person, subsection 4, may apply to the commission for a copy of that nomination form, affidavit, and any other document submitted by the candidate at the election, and the commission shall, upon payment of a fee, issue such with a certified copy of the document. See what subsection 5 says. A person who has reasonable grounds to believe that any information given, this one now gives every person the right. Any person who has reasonable ground to believe that any information given by a candidate in the affidavit or any other document submitted by the candidate is false may file a suit at the High Court of a state or Federal High Court against such a person seeking a declaration that the information contained in the affidavit is false. Are you following me? If any person. Then finally, sir, subsection 6 says, if the court determines that any of the information contained in the affidavit or any document submitted by that candidate is false, the court shall issue an order disqualifying the candidate from contesting the election. As I told you, this is a pre-election matter. Now, section 87, finally, subsection 10, gives the candidate himself who contested alongside. That is section, look at it here. 87. 87, stop section 10. It says, an aspirant, 87, maybe.
87.
Okay, 10, sorry. Notwithstanding the provision of the Act or any or rules of a political party, notwithstanding whatever the Act says or any rule of an aspirant now, that is the person who complains that any of the provision of this Act and the guidelines of a political party has not been complied with in the selection or nomination of a candidate of a political party for election may apply to the Federal High Court or the High Court of a state for a redress. So
which is what
Uche. So
did.
now, as I said, this is a pre-election matter. It's not election.
Okay.
It's a
Just hold on.
Yes.
I'm going to ask you to respond.
Yes.
But let's just take a short break. When we come back, because I want to get another person on the program.
Yeah.
When we come back, I'm going to ask you to respond, and then would want to get the view
respond
of...
well.
Yeah, you're going to respond well, of course. You're going to respond to what he said. So we'll take a short break now, and when we come back, we'll continue this discussion. Every day, every hour, and every minute, news break in Nigeria. Things happen so fast, it's most times difficult to track and comprehend them. But that's what we do right here on DEJI360. 2015, would you want to come back again?
It's like asking Jesus Christ if he knew he was going to die, will you want to come back as the savior of the world again?
We do not just help you track the stories, we break them down, explore all the angles, analyze the issues so that you can fully comprehend the stories and use them to make the right decision.